All right, so we talked about all of these, right? Assignment, novation, mutual agreement, operation of law. Now, we have contract remedies. If one party breaches or the other, we can sue the other party. Now, if I'm the seller and the buyer breaches and walks away, in the contract, it's going to tell me what I can get. And that's the earnest money. And that's going to be liquidated damages. That's going to be called liquidated damages, all right? And this is a fixed amount of money that we agree to if one party or the other breaches, okay? So it's usually the earnest money. If it's the seller who breaches, the buyer's going to be able to get back all the money he's spent, earnest money, due diligence money, and funds that he spent on inspections and appraisals. So we do have remedies for that. Okay, so we can sue for consequential damages, lost profits. If the earnest money, let's say there's no real big earnest money, then and I lost a lot more than just what you put up, then I can sue for more money, right? We talked about specific performance, right, before. Buyer can want that house and then sue for that, enforces the right to buy that property. Parties can get together and get out of the contract and just say, all right, look, we don't want to go through with it. One side wipes out the other. All right. And we also have to make sure we have statute of limitations. Time is of the essence in all of these contracts, right? We have a certain amount of time to do everything. So that is a statute of limitations. If you're beyond that time frame, you have no bearing or no jurisdiction. It's sort of like even, just to give you one example, in the contract, it's going to tell you that if we come to the closing date and we're not ready to close for one reason or another, we're going to give an automatic 7-day extension. But after that automatic 7-day extension, there is no more. That's the end of the time. Okay. Now, the buyer and seller can agree to get into an extension agreement, but the seller or the buyer can walk away at the end of that. Okay. Without being in breach. So that's just an example of statute of limitations. Very, very important slide here. You as the broker are not allowed to practice law, which means you are not allowed to draft amendments or addendums or contracts, period. You're not qualified. That belongs to the attorneys. Let them do it. Find yourself an attorney friend. If you have a problem or you have something that has to be written up that we don't already have addendums for, then go to the attorney and have them draw it up. We have about 14 different standard addendums that we can use to fill in. That usually covers everything. But if something that needs to be done, we usually already have a form for it. So use those forms. There's too many ambiguities for you not to use them. You've got to make sure the who, what, when, where's, and why's, and that's what the attorneys do. Let them do it. If we're going to make any changes or additions or anything else, we want to make sure those things are dated and initialed by all the parties. Dated and initialed by all the parties, everybody. Okay. We made the changes on this date, make sure they're initialed. Contract law and auction sales. Auction sales work a little differently. There are two types of auctions. The first one is with reserves. And what does that mean? Let's say I'm selling my house at an auction, but I want to make sure I get $300,000, all right? And I see that the bids, they're bidding on it, and I see it's not going to get there. I see it's going to be about 240, 250. If I have a reserve auction, what I can do is stop the auction before the final gavel hits. And I can stop it and say, all right, withdraw the auction. Never mind. Okay. And then they would stop the auction. We would pull it back and we would try to sell it at another time. Okay. Basically, it's not going to sell today. Not going to hit the price. Not going to hit the price that I want for it. It's not going to sell today. That is a auction with reserve. I have the ability to take it out. Now, if I have an auction without reserve, then whatever price they get, and I have to take that. So if I see that it's going to settle at 250 or 260, and that's what the gavel hits at, I have to accept it. I can't withdraw it once we get it. So that's what's called an absolute auction or a without reserve auction. Okay. So I put it out there. It's for sale. Highest bidder is going to get it. I have no right to take it off the market once we do that, once it goes to auction. Right? Now, the auctioneer can bind the seller. I'm going to give my property to the auctioneer, right? And I'm going to say, sell it. Well, once that gavel hits, the auctioneer is going to bind me to sell it for that price. It's going to handle the sale. All right, so Chapter 9, we went through a few of these terms, just kind of go through it. Bilateral contract, 2 parties, right? We have I promise to bring the money, you promise to bring the deed. 2 promises, okay? Unilateral contract, 1 promise, right? I promise to sell. I'm waiting for you to decide whether you have to, whether you're going to come back or not. Okay, so I have 1 promise for 1 act. Only 1 person's committed. Counter offer is any change in the original offer. Any change, be it an I dotted or T crossed. Okay, any change is a counter offer. We talked about valid, void, and voidable. Valid has all of the proper 4 contingents, parties. Void was missing one of those. All right. Voidable is somebody who is under duress, under age, or intoxication, and they can still go forward with it, but they have the ability to get out of it. Express contract is with words, orally or writing, but is spelled out specifically with words. Implied contract is by your actions. Think restaurants, right? You don't have to sign a contract to go eat something in a restaurant, but you have to pay the bill at the end. It's implied you're going to pay. And meeting of the minds means we have what? We have agreement. I have the reality of consent to what I'm going to purchase. You have the reality of consent to what you're going to sell. Okay? So that is the meeting of the minds. On Sunday, an agent receives a written offer from a buyer for $145,000 on a townhouse. He is listed for $154,900. On Monday, the seller counteroffers at $149,900 and gives the buyer 3 days to accept. On Wednesday, buyer rejects the counteroffer, and upon being informed, the seller says he will accept the buyer's original offer. Under these conditions, there is what? What do we have? Here's the choices. We have a valid agreement for $145,000, a valid agreement at $149,900, not a valid agreement because the buyer's original offer was rejected, and D, not a valid agreement because buyer's offers was not accepted by Thursday. Yeah, and the answer is C, right? The answer is C. Once we reject that first offer, we can't go back. We are not allowed to go back. So once we reject that first offer, it's done. So the answer would be C. True or false? Barbara is so excited to be purchasing her condo at Cure Beach. Is it Cure Beach? I never pronounce it right. That she stops off at the Sea Witch Cafe for a couple of Long Island iced teas prior to sign the offer to purchase and contract. That's our contract. That's what it's called, OTP&C. This would automatically void the contract. Would this automatically? No, right? Maybe she still wants to buy the property, right? It would be voidable, but not automatically voided, right? Sounds like she's celebrating. A buyer walks away from a transaction 1 week prior to closing, forfeiting their earnest money as a result. The seller collected the earnest money is an example of what type of legal damages. Okay, so this is liquidated, right? This is liquidated damage. So would they get that? All right, it's automatic. It's in the contract. We'll see it when we do chapter 10, okay, which will be next. True or false? In order for real estate sales contract to be enforceable, there must be an exchange of things of value between 2 parties. Yeah, right? There has to be consideration, valuable consideration. So absolutely. Right? It has to be, it can't be for love and affection. If something is for love and affection, like grandma giving me a piece of property just because I am who I am, that is a gift. That is not a contract. All right? That's a gift. In this particular case, we have to give something of consideration. Now, it doesn't have to be money. Could be money. Probably most of the times it's going to be funds, but it could be anything. It could be another exchange of a house. It could be inventory. It could be stock. It could be anything you can think of that's valuable, we can use in exchange, but it has to have value, right? It has to have value. A minor who is almost 18 years old signs a contract to sell real estate. This would render the contract what? voidable, right? Voidable. It is voidable by the 18-year-old or by the 17-year-old. Not voidable by the other party, voidable by the 17-year-old. Or 16 or whatever at the seller's request. All right. So that is chapter 9 in a nutshell. That's kind of the overview of contracts. 30,000 feet overview of what a contract is. In chapter 10, we're going to get down into the weeds a little bit, okay? We're going to talk a lot about our sales contract, the sales contract that we are going to abide by. And this will be hopefully not your first look at it, but if it is, then great. We're going to spend some time with it. Sales contracts and practices. This is talking about us. What happens with us in our particular contract, all right? That's what we're going to deal with. The North Carolina sales contract, we're going to see the North Carolina Association of Realtors, NCAR, all right? This used to be the NCBA/NCAR Standard Form 2T Offer to Purchase and Contract. NCBA says being the National North Carolina Bar Association / North Carolina Association of Realtors Standard Form 2, okay? We're going to call it either the OTP&C or the contract, all right? The offer and contract, same thing, all right? Now, it doesn't have to be this form. It could be any form that's drafted by an attorney that meets all of the standards of Rule 112 in the Real Estate Commission Handbook. There are 19 different provisions. Last I checked, there could be more by now. 19 different provisions that must be in every sales contract. And it could be written, as long as the attorney writes it on a cocktail napkin and he writes all 19 of these in, it's legitimate, okay? You can't do it, I can't do it, but the attorney can. So when you go to new homes, you may see a completely different type of contract, but it's going to have all the information in there that's required. If you get to a for sale by owner who's had an attorney draw up a sales contract, as long as it's got all of those things in there, it may not look anything like what we're going to see, but it is legitimate, okay? If you buy something through a foreclosure or anything else like that, you may get a trustee's deed. It may look different, but those things would have been written up by a North Carolina attorney and have all of the implements in place. So not everything is going to look like our contract. However, when you get into your real estate practice field, this is the form you're probably going to use, some sort of rough form of it, okay? So we want to make sure. The North Carolina Statute of Frauds requires any contract for the sale of real property to be in writing. Anything, all right, for the sale has to be in writing to be enforceable. So the Real Estate Commission leans pretty hard on that. There's no such thing as an oral agreement. And even if the buyer and seller agree to something verbally, unless it is reduced to the four walls of the contract, the conversation never happened. Conversation never happened. It must be reduced to writing and signed off in the contract. Now, as we go through the contract, you're going to see it's pretty comprehensive. There's a lot of stuff in there, and there's some things in there that we're gonna hit the highlights, but there are some things in there we're going to read through because things that need to be done. So this has to be done, and if they agree to something that's not in here, we're going to use the need. We're either going to have to use an addendum form, an amendment form, or we're going to have somebody write it in. Cannot be oral. No such thing. So if they agree to leave the washer and dryer, we're going to show you a line that's going to be where you put the washer and dryer. All right? Because if you leave it out of there, they don't have to leave the washer and dryer. So it's really important that everything they agree to is in the four walls of this contract. All right, so the offer to purchase and contract, OTP&C, sales contract. This is a contract for residential resale, okay? Remember I said new homes would probably use a little tweak of a different contract? Well, that's why. Vacant land has different contract. New homes has different contract. Same stipulations, but again, different. Did we ask that question? Does anybody know the difference between an addendum and an amendment? An addendum is we're adding something that's not in the contract, we're adding something to the contract. An amendment is just we're taking something that's in the contract and we're changing it, okay? So that's the difference between the two. We're talking about the Form 2T offer to purchase. Now, before we even go anywhere, I want you to look at the bottom of the first page. In order for us to make sure that we have the most recent contract, make sure that this lower right-hand side has the most recent date. And this is the most recent form of this contract. Okay, 7/22. We need, right here on the top, we need all of the seller's names and all of the buyer's names. Now and it's got to be in some sort of detail. Mr. John T. Jones and his wife, Mary K. Jones. Okay, in that format. Full names, not Mr. and Mrs. Jones, or not seller of record. They have to be clear and specific. And those are the persons on the deed. Those are the sellers. Now, the buyers are going to be the persons who are fiscally responsible. Who's coming up with the money? All right. And again, they have to be full names. All right. Full names. Now, if those four guys who are selling that golf condo, all four names have to be in that seller line. That's why we go to an additional seller lines, additional signature lines, things of that nature. They all have to be here and they're all in agreement, so they all have to sign. And in the buyer, or the seller rather, those they have to be on the deed. Whoever's on the deed, those are the ones that are selling it. Okay. I showed you where we can find that information, right? Just go to your county land records, you can find who's on the deeds. And in the buyer, obviously, driver's license names are good. Now, we also talked about legal descriptions. And we are going to put the street address in here. That's fine. It's a good placeholder. But underneath here is the legal description. Block, section number, subdivision, right? Plat, slide number, all of that stuff. What pages? Do they have a property identification number? We want it here, all right? Any other identification. If it's in your county maps, if it's in your county land records, we want it on the contract, okay? It's easy to find. I'll show you where it is. Under the next section here, it is the purchase price. What I want in this first line is how much you're going to pay. What's your offer? So let's say for easy math, we're going to put $300,000 in for an example. Okay. In this first line, I would pay $350,000, $300,000. All right. 300,000 is our price point. In this next line, if I'm the buyer, I'm going to give the seller some due diligence money. When we get to number 4 here, we're going to go into depth about due diligence money. We'll spend some time doing it, talking about it. So we are going to put up some due diligence money. Now, due diligence money and time is negotiated. Whatever the buyer and seller, I have talked to 100 different agents. They all come up with a different dollar figure for due diligence and a different time frame. So please don't hang me out with your brokers in charge, but for the purposes of this class and educational purposes only, let's use $500 in due diligence money and 21 days to get the work done. That is not a standard by any means, but it helps us get through the understanding. We're going to write a check as the buyer for $500 and we're going to give it to the seller. We're going to write that check to the seller and we're going to give it to them for due diligence money. Now, or we're going to give them cash, or we're going to give them a personal check or a bank check or wire transfer, or whatever way we're going to do it. And I check this over here. So we're going to put that in here, $500. The next line is going to say how much initial earnest money deposit you're going to put up. Now, that first earnest deposit money does not go to the buyer or to the seller. The due diligence money goes directly to the seller. Written check written directly to the seller. The earnest money goes to the trust account. All right. So we're going to write a check for the trust account. So let's say $10,000. I need to add one thing here. Remember I said that we had to have consideration for our contract, something of value. So if I say I'm going to bring $300,000 to purchase this in the contract, do I need to put earnest money up? Is earnest money mandatory? It is not. The consideration is the offer price, right? The consideration is the offer price. So if I'm the buyer and I don't want to put up any earnest money, I can put a big fat zero here. Now, you got to ask yourself if the seller would accept that or not. But the seller probably wouldn't accept it. But by law, I don't have to put anything up for earnest money. My promise, the promise for a promise is I'll bring you $300,000 in 30 days. That's it. Now, the seller's not going to accept no earnest money. All right. The seller's agent's hopefully smarter than that. Let's say he wants 1% down. So $300,000 purchase price. We're going to put $3,000 in earnest money. Okay. Everybody agree with that? We'd write 3,000 here. Okay. So just to make our lives just marginally more abbreviated, so we can kind of get a look at this. All right. So we put 300,000 there. Then we would do our deductions. We said we would put 500 in due diligence. We also said that we would put $3,000 in earnest money. We're just going to do one-time earnest money. So we're not going to put anything on this line. We're going to put zero. Another note in contracts. Blank lines are not your friend. Don't leave lines blank. NA/0 is all good. You leave it blank, and I can promise you the temptation for somebody to fill it is there. We're not all dishonest, but you leave it blank. Don't lead us not to temptation, right? Remember? We're not going to give them any additional earnest money. We're giving them the 3,000. But I want you to pay attention here. Time being of the essence. Anytime you see the words time being of the essence in this contract, what that means is that is a drop dead time frame. There is no extensions on that. So if this says that this money has to be in the bank at 5 p.m. on February 15th, at 5:01, this contract can be declared void. So when it says time is of the essence, that is a hard date. All right, that is a hard date. And we're going to see that in due diligence when we get down there a little bit. So I wanted to break it in right now. All right, anytime we say that. Now, are we going to have a loan assumption? Probably not. So let's just say 0 there. All right. We're going to do seller financing? No, probably not. We're going to go to the bank. Are we going to put a building deposit? This isn't a new home, so we're not going to do that. So I'm going to take my 300,000 and I'm subtracting my 3,500, right? 3,500, 3,500. And it's the last line says the balance of the purchase price in cash at settlement or your loan amount. All right. So if I do that, it's going to come to 266,500. That's the balance. That's what I need to get a loan for and cost. So all I did was I took my purchase price and subtracted all the things I'm putting up right now. A couple of things. I'm the buyer. If I go through with all of this stuff and we go to closing, I'm going to get a credit back from the seller for $500. He's going to give me back my due diligence fee if I close. And I'm also going to get a credit for my earnest money, my $3,000. I'm going to get that back, okay, as part of the closing cost. So both of those are going to be buyer credits later if we go to closing. So just understand that we'll get those back, all right? If we don't go through with it, we could lose our $500 and we could lose our $3,000. So we're at risk here for $3,500. Okay, the bottom of page 1 of 16, we have the buyer's initials, everybody should initial it, and the seller's initials, everybody should initial it, okay?
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.